Karen, just to be clear, you didn't do it.
We know who did it, Steve. We know. And we know who spearheaded this cover-up. You all know.
Yes, we do.
If John was beaten up and attacked in that house, who did it?
We don't know.
We don't know.
We don't know. And it's not for us to know. Somebody other than Karen is responsible for that, for the killing of John.
Roberta in the truth zone, mic hitting raw. Spotlight shining, she exposing the flaw. Debunking the myth, breaking their facade. This is Glass City, respect the squad. On these NYC blocks where the skyline flex big. Roberta Glass slicing lies with a truth rig. Innocence frosters, your stories unravel. She's a map through the madness of gritty gravel. Glass don't bend and facts don't break. She's the storm that's called, you feel the quake. Exposing tales stitched with crooked seams. Justice in the lens, shattered fake dreams. Screams about killers, painted heroes in disguise. She burning propaganda with fire in her eyes. No glamour for the guilty, she call it straight. She backs victims, the voice stay awake. Stats and receipts, no spin, no clutter. Cold cases whisper, she cuts through the mutter. Truth's her tempo, don't confuse the beat. She's standing for the real while you taking a seat. True crime's a block, facts the artillery. Spinning those lies, yo, she checks that misery. Tabloid tales get smashed, no time to play. She's glass hard, break the false and save the day. True crime's a block, facts the artillery. Spinning those lies, yo, she checks that misery. Tabloid tales get smashed, no time.
Okay, how is everybody? Miss Lisa, today was a very good day. Very good day for another great day for the Commonwealth. Now, I don't know who's on the jury. Now, the Commonwealth can have a zillion great days if they're turtle riders or free Karen readers or whatever you want to call them on the jury. None of this matters. We're headed for, in that case, we're headed for another hung jury. Could be. So please don't misunderstand me. I'm making no predictions as to how this comes out. Please don't confuse Karen Reed's guilt with an outcome in this case. We've had a full-blown innocence fraud campaign led by Karen Reed and her lawyers, which the press has gladly jumped on. And the propaganda is high. It is powerful. Please don't confuse her incredible guilt and her getting absolutely demolished in the courtroom with a pat outcome. Like, oh, checks in, right? It's already done. It's already done. It's a guilty verdict all the way. I can't say that. Hey, Lori. Hey, Taterbug. Hey, Maestro. Hey, your latex spouse, if you're still at the chiropractor. Hey, Amy Celeste. Hey, my King of Kings. Natalie B. Doris. Please hit the thumbs up. Sandy D. Second Beach Gal. Nice to see everyone. Coercive control is a crime. Jennifer Ray. The great Tony Natali. I saw you in the chat. Hello, hello, hello. All right. So I'm going to go backwards today. So what happened today in court? The defense presented their case, and they brought up Matthew DiSorga, who specializes in vehicle data analyst. Let's put it that way. And lo and behold, he was asked to write a report that at the last minute on the 25th, that was handed in on the 25th. So all this nonsense about how dare the dirty Commonwealth amend a few things or get rid of one or two slides that they were going to show before a trial. They have actually didn't write a report, but a presentation, let's call it. But this guy did not do any reconstruction. He didn't write a report. He just analyzed all the Commonwealth's data and made it into a PowerPoint presentation. So that's what Matthew DiSorga did, and he was demolished in Cross. Might go more into that tomorrow, over the weekend. But I want to start with the end of the day, which was the most explosive, because it proved what I've been saying all along. They do not want to call Michael Proctor to the stand. Because it would bring in, Yanetti's called it their closing argument all over again. It would prove he would basically make their closing argument for them. It's much better not to have Michael Proctor say, well, what did you get fired for? Oh, mean texts, and I had a beer and I drove, or a couple beers and I drove, whatever he had. I drove my police cruiser, those two things. And Karen Reed somehow got a hold of my personal text messages and I was talking crap. Might be very relatable for the jury. And if he's not relatable, for the ones that he's not relatable, it allows on cross a reiteration of Karen Reed's guilt. So we had Proctor's childhood friend. When I say childhood friend, they've been friends through to seems like now. Jonathan Diamandis on the stand. It was a pretty boring. He was in part of the group text message. He made one comment. It was a pretty boring voir dire. But right after that, we had the arguments, and that's what I'd like to get into, about why they should. So here's what let me not be confusing. Let me try not to be confusing. So this is what the defense is trying to do. So instead of calling Proctor, they just want his text messages in so they can horrify the jury and show bias, but they don't actually want him in. Right? So they're going to try to get his text messages in, more of them. They got a few in through Buchanan, but they want all of his text messages in by calling the people who were in the group chat. I think this is what these four people are. This is what I'm assuming these four people are. Maybe it's something different. Maybe there are four that they brought on their witness list at the last minute. So they think this is a great strategy so that Proctor doesn't get on the stand, can't highlight the evidence that points to Karen Reed's guilt in cross-examination, won't have an opportunity to be either liked by the jury or pitied by the jury or believed by the jury. Okay? He can stay the shadowy monster that they've made him out to be. Right? It's like in one of those things, okay, maybe this is an old reference, but Charlie's Angels, you never see Charlie. He's the all-powerful. He's just like this voice. Right? It's not great when you see the Oz behind the curtain, right? It's much better to have the jurors use their imagination and imagine him to be this incredibly corrupt, out to protect the police and frame the convenient outsider. How magically, he had no time to do it, but never mind that. He's apparently all powerful, manipulating car data, phone data, planning evidence. This is according to the defense in this case. It's much better to have the jury imagine him, right? Keep him as the boogeyman. So the most fascinating part of the day today was hearing Hank Brennan and David Yannetti argue over this. And Hank Brennan's like, look, I don't object to you bringing in Proctor's text, but bring in Proctor. Bring him in. I dare you. It was like a standoff. It's like a Wild West standoff we watched today. If you're listening, please hit the thumbs up. Let's get this algorithm going on this Friday night. Perfect way to start the weekend with this fabulous I mean, I'm not much for these voir dires, but this argument was really quite compelling. Let's take a look at it, shall we? Here we go. Let me just get it like this. And so here's Yannetti. So just to set the stage, Jonathan Diamandis, his Proctor's friend from childhood, who was on that group text, has just given a short voir dire. Not much was really said, except that he made one comment that he doesn't even remember making. But that this group text messages between all of Proctor's childhood friends had gone on for, quite some time. And there's another thing, that Proctor has held on to his friends for so long. It's another thing in his favor, no? That might make the jury look at him in a favorable light. So here's David Yannetti, finally. He's been like a phantom in this case. He's done so little. It's been all Alan Jackson and, sadly, Robert Alessi doing the lawyering for Karen Reed, standing up and talking about why they should be able to bring in Proctor's text messages without bringing in Proctor via the people in the group text message. Let's take a listen.
So, Your Honor, with regard, I assume we're just dealing with authenticity at this point?
No, we're dealing with both. You're the proponent of the testimony, so let's deal with both.
Okay, all right. So, regarding authenticity, Your Honor, there are several ways that are either independent or connected with each other by which, or through which, a party can authenticate text messages. The majority of the case law out there are defendants having appealed judges' decisions to admit text messages offered by the Commonwealth, and the majority of the case law that exists affirm judges' allowance of text messages into evidence. The Commonwealth filed a memorandum in opposition to these text messages being admitted, and not one of the cases cited by the Commonwealth apply here or are appropriate. The case of Commonwealth versus Purdy, in that case, the Commonwealth introduced text messages from computers seized at a massage parlor. The defendant objected that there was no evidence that he had authored any of the, these actually were emails, not text messages, any of the emails that were admitted into evidence. Nobody saw him do it, nobody saw him type it, and nobody discussed any of the emails with him. But the SJC cited a long-standing rule, including Rule of Evidence 901B1, 4, evidence may be authenticated by direct or circumstantial evidence. And the circumstantial evidence is essentially what we covered here in court today: the appearance of the electronic communications, the content, the substance, internal patterns, or other distinctive characteristics. Commonwealth versus Welch, it was a murder case where a boyfriend killed his girlfriend, was charged with killing his girlfriend, was convicted. The Commonwealth sought to introduce text messages between them, and various text messages from the victim's cell phone were admitted into evidence because, for one reason, they referenced the defendant's distinctive nickname. And in this case, we have a text chain with 3 nicknames, all of whom the witness recognized as being his friends. We have more to authenticate.
Right. So Proctor, we found out today that Proctor's nickname was Chip. But the Commonwealth isn't disputing that these text messages came from his phone. He was fired over these text messages. This is obviously, I've heard the judges already ruled this out, that they can't. So I kind of buried the lead here. They can't do this. That they have to bring in Proctor. They can't sneak him in the, bring in the text messages without bringing in him. And with everything that he carries, which is intense, detailed knowledge of Karen Reed's guilt. So they can ask him, why didn't you, paper off the crime scene in a blizzard in a 500-mile radius and interview everyone, every house? Why didn't you interview, why wasn't the Alberts who own the home, going to catch any shit? It's funny, because you can say that text message like, he's not going to get in any trouble. Oh, did you know he's a Boston police officer? He's a cop. The way the defense team have put the inference is like, he's not going to get in any trouble because he's a Boston cop. Not because nothing's going to happen to them, because all the evidence points to Karen Reed. That's what I meant. Put him on the stand. Have him say that. What I meant was not that. I said, oh, by the way, he's a Boston cop too, but they're not getting any trouble because all the evidence points to Karen Reed. She told people at the scene, I hit him. She knew that he was dead before anyone else. She knew right where to find him. Her taillight was smashed all over the area of the lawn that she left him. And there's no ability for anyone to plant this evidence. I mean, and strangely, her car data supports it. And his phone stops moving right after she goes in reverse. With, her foot 74.5% down on the gas pedal, 24 miles an hour in reverse, with her infotainment system beeping and flashing at her, telling her she's going to hit something. I mean, I've heard people say now the real Karen Reed apologists are saying she was blackout drunk. Even Karen Reed said she wasn't blackout drunk. It would be a great defense for her to try to minimize it like I didn't know. But if she was blackout drunk, she wouldn't know where to find him. She wouldn't know that he was in danger or dead before anyone else. I mean, this is why I think they could have given her a murder one charge, frankly. Premeditation does not mean that you planned it for months and months and months. It can be seconds. And there was obvious to me premeditation in this. And I think that she was fantasizing about teaching John a lesson. And here was her opportunity. No one was going to leave Karen Reed.
This text chain than in any case I have seen, and also more than in any case the Commonwealth has cited. In this case, we have an identification of every phone number pursuant to the last two digits. We have an identification of Michael Proctor's message relating to the contents. We have evidence of the witness's cell phone requiring a passcode, meaning that in order for his phone to be active in this chain, he would have had to have unlocked the phone with the passcode. And he testified that what was in the content of the message that he identified as being his is consistent with something that he would have said. And not only that, but he adds a fourth nickname, that being Chip, that being Michael Proctor. The Commonwealth with regard to Commonwealth versus Welch, which is again cited in their memorandum, this opposition, Your Honor, they state what appear to be rock solid black and white legal principles, but when you scratch below the surface and you actually read the case stands for nothing in terms of what they've represented it to be. They stated that in Welch, the court must find that each and every communication was authored by the individual member of the group. That's just plain false. The case doesn't say that at all. It's nowhere in that case. And in fact, the messages were let in, again, because of the circumstances and the content of the messages. Commonwealth versus Raposa, another case that they cite. The defense sought to call a neighbor to testify that he had seen the victim alive after the defendant had confessed to having shot him, another murder case. The problem was that the neighbor denied making the statement, so the defense wanted to call the neighbor for the sole purpose of impeaching him with his prior statement that he supposedly made to the police and use that statement as substantive evidence. So in that case, the defendant wanted to use an out-of-court statement for its truth. It was rank hearsay. That case had nothing to do with text messages or statements used to show state of mind or electronic communications. But somehow it makes its way into the Commonwealth's memorandum. Commonwealth versus Rajiv R., which is the second to last case that they cite, that dealt with a search warrant done at a juvenile's home. The police officer in that case was allowed to testify to what he was seeking, which was the goal of the search warrant, a firearm allegedly in the juvenile's possession. And he was also allowed to testify to what the juvenile's mother did during the execution of the search warrant, which is she directed the police to the juvenile's bedroom. The Commonwealth cited that case to say you can't use hearsay when trying to prove a Bowden defense or present a Bowden defense. That case had nothing to do with Bowden. The evidence was admitted to explain what the police were doing in the home. So it's a situation where, there are times when, the police stop somebody on the street or the police get a search warrant and then they show up at a home. And rather than just have them magically appear at the home with the warrant, the police are allowed to give some circumstances as to how they got there. Nothing to do with Bowden. It's just giving the jury a fuller picture. Yet it was represented to you by the Commonwealth that, geez, this is a Bowden issue and you can't use hearsay to present a Bowden defense. Commonwealth versus Sullivan, exact same situation. Testimony was admitted about DNA on evidence matching the defendant's DNA from a national database. The Commonwealth cites three principles. It's almost like they're setting a standard down that the court is supposed to follow with three factors. But again, none of the three principles that the Commonwealth cites is found in Sullivan at all. They're not even mentioned in the case. They're simply made up and put in a memo to ask this court to do something that the case does not support.
So he's saying there's no support in any of these other cases that made precedents. The Commonwealth is lying. And it's curious. What I'm thinking about is I'm wondering if had they made this argument, had Yannetti made this argument last trial, would Judge Cannoni just have taken their word for it? Because she doesn't take their word for it. She's like, well, I'm going to have to investigate this case law myself. Had they been caught lying to the court too many times for Judge Cannoni to take their word? Certainly, Yannetti is a heavy hitter in Massachusetts. He's made a name for himself defending drunks and killers and predators. And it just seemed like the first trial, I keep calling it first case, first trial, Judge Cannoni seemed like in awe of Alan Jackson and David Yannetti. And now that they have embarrassed her, by showing how she lets just things fly in her courtroom. Anything goes, has no control over it. I mean, they lied for over a year with ARCA. Just handing in, oh, we can't talk to them, Your Honor, we can't talk to them. We're not even paying them. We're just putting these witnesses on the witness stand that we've never spoken to. We have no idea. We're just rolling the dice in a murder trial and seeing what our witnesses say and hoping they'll be helpful to us from their report. We don't know who did what, whatever. I mean, all of it was a lie. All of it was a lie. And then she tried to lay down the law and was like, no more lying. And they lied within minutes. Minutes after that, they started lying again. So that's what I'm thinking about. I don't know about you guys. I mean, they're just claiming the Commonwealth. They're calling the Commonwealth a liar, and essentially here.
And again, it has nothing to do with Bowden. So now we come to the arguments about the fact that the Commonwealth is claiming that these statements are hearsay. They're not. These statements contain insults of my client. I'll be kind and just mention the word.
So I read them.
Yes, okay. Well, I mean, Your Honor, if you're going to allow this into evidence, I'll stop talking. Otherwise, I have to make my argument.
I understand what you mean by insults.
Okay. So I won't even mention them then. The Commonwealth is essentially arguing.
Fascinating little moment. Your Honor, I'll stop arguing. If you're gonna approve this, I'll stop arguing now. She's like, no, I know what you mean. I've read the text messages. First, I thought I misunderstood the first time I heard it. I was like, does she mean she's read this case law recently? Oh no, she's talking about the text messages. She knows Proctor's text messages. We all do. We all know them practically by heart now. You've been following this case. Who doesn't know Proctor's text messages? Oh, whack job. See you next Tuesday. I mean, so much so that, we all could recite them.
That we're offering these text messages to show that the insults were true. That's a silly argument. Obviously, we're not. Hearsay has three components. These are all statements out of court. None of them are offered for the truth of the matter asserted. None of them. Even the statement when Michael Proctor says that the homeowner's not going to catch any grief because he's a Boston cop.
See, that's not what he said. He says he's not going to catch any grief. And then he says he's a Boston cop. They don't say, he never says because he's a Boston cop. He just mentions he's also a Boston cop. It's the defense that's changed it just slightly. But I love that they say they're not presenting his text messages for the truth of the matter. Your Honor, we're not presenting these text messages to show that our client is, quote unquote, excuse my language, retarded, unquote. We're not, Your Honor, we're not sharing these text messages to prove that our client is a whack job. See you next Tuesday. That's not what we're trying to do here. Boy, did I laugh when I heard that.
We don't know if that's true or not true. It's offered to show that Michael Proctor believes.
Well, I think that Karen Reed has proved it to be true with her own actions. I mean, who else but a whack job, see you next Tuesday, would speak about the victim, the victim's family, disparage them, start a witness harassment campaign, say she's not called a family stupid of the man she murdered. She doesn't sit with stupid. Remember that text message she wrote? Says she has no feeling for any of the witnesses whose lives have been totally made like a nightmare by her in her need to get out of taking responsibility for the murder she committed. She's proved all those things to be true. Yannetti?
believes it's true. He's the lead investigator in the case. He has input into the case. He can decide who's investigated or not investigated. At least that's our argument. It's all consistent with our defense. It's offered to show his state of mind. Everything that he says is offered to show his state of mind and to show his bias. He, as the lead investigator.
But they've already gotten in that text message about him being a Boston cop in the opening statement. This is just a way of centering Proctor into the story without actually calling him. And I found it fascinating. Because I just noticed that when she was asked, are you going to call Proctor to the stand? You know, to be determined, TBD, TBD, TBD. Who talks like that anyway? If I ever start talking in little abbreviations, like a little emojis, please bring it to my attention. So awful. I was like, why? They really aren't going to call Proctor. And I'm starting to think my girlfriend's right. They may not call Arca. They may not call Marie Russell. I don't know. I don't know who they're calling. But certainly not Higgins or Proctor and not Karen Reed. That's what it's looking like. Maybe wrong. Maybe they'll call Higgins. But certainly are doing everything they can to avoid calling Proctor.
Investigator, his bias in what he does or doesn't do. And in fact, Mr. Brennan said at sidebar earlier when we started this conversation that Bowden deals with what was done or what was not done. We're entitled to explore what was not done and not done, and we're entitled to explore why. We have evidence of why. We have Michael Proctor's words about why he did or didn't interview people separately, why he waited, for instance, a year and a half to interview a plow driver who was out there on January 29th, why he treated some people with kid gloves and other people with brass knuckles. He's stating it in these text messages.
See, I had a totally different take, but I appreciate Act Out you bringing this up. Yannetti hates Hank Brennan suggesting what their strategy should be. That to me means they lack confidence. The defense does yesterday, unless he got triggered with Dr. Welchler moving his hands. Yeah, that was odd. I played that this morning. It was really odd. He just had a full temper tantrum meltdown, baby meltdown at the podium. I did see the comment. Carl is welcome anytime he wants to debate this case. Anytime he wants to come on my show and debate this case, he is welcome. But he never will. And I don't say that as if he wants to come on, he can discuss it any time he wants. I'll come on his channel. He can come on my channel. But my experience with innocence fraudsters like Carl Steinbeck is that they never debate. They never discuss. They only want to do softball. They want to do monologues or softball interviews with people on their side. Happy, But the way I see it, Yannetti was just avoiding the fact of the case law does not support the way they're trying to bring in Proctor. And the way that Yannetti deflected it was by saying, well, Hank Brennan's telling us how we run our case. I appreciate that, but we'll run it with the strategy we see fit. So it was a way to deflect. I don't think it did show particular insecurity or lack of confidence. They're just trying to get this. They don't want to talk about the lack of support in the case law. They want to make his argument about Hank Brennan is such an experienced defense attorney that he actually wants to play both roles. He wants to play prosecutor and defense attorney, and he can't play both roles in this courtroom, Your Honor. It was a real deflection over the real salient points brought up by Hank Brennan. We'll take a listen in a minute.
She's gonna go down for this. We're gonna pin it on the girl. We're going to make sure that there are some serious charges. She's effed. Those are what he says about, those are the statements he makes about Karen.
He doesn't say we're going to pin it on the girl. She may be effed, but that's her own doing by her own actions because she did it. But, you know, he never says let's pin it on the girl. That was made up by the defense. So, I mean, they're throwing fact and fiction. And because they have such a soft judge, harder judge would say, what are you doing? You can't make up dialogue here in court. Have you ever heard of evidentiary support for your argument? You can't just make up lines he never said. Better judge would say that, but not Cannoni.
Karen Reed in the infancy of this investigation. And to the contrary, is anything going to happen to Brian Albert? Nope. He's a Boston cop too. These are all statements about Michael Proctor's state of mind. The prosecutor and I have been over the statements. I realize he's objecting to the admission of these statements. I don't think he has a legal argument that passes muster to do that, but should the court allow them in, we're agreed on everything except for 3 entries, which I think we could deal with pretty quickly. And unless the court has questions, I'd rest on that.
No, but I'd appreciate a copy of whatever you've agreed upon.
Okay.
So it's been a long day for staff, so I don't need to sit here and go through each one. Just get me a copy of what you've agreed to.
Okay. So this is the only marked copy. I'm happy to hand it to the court.
And you can take care of it and email it in.
We'll do that. Thank you, ma'am.
So, Mr. Brennan, I'd like to hear you on admissibility. I haven't decided admissibility, and I'll hear you on authentication.
On the first issue of authenticity, this witness has no memory of any of the text messages. I think it's fair to conclude he's on the text message string. He recognizes the people on it, but there is no authenticity if he doesn't recognize them. The person that could best authenticate these text messages is Michael Proctor. This witness does nothing as far as identifying the individual text messages and whether they're reliable, whether there's been any additions, deletions, whether in sum and substance this is part of the conversation. Notably, I think, according to the questioning by Attorney Yannetti, he's made one comment at the end of the string that really has nothing whatsoever to do with the text messages that are at issue. So authenticity, I don't believe this witness reaches that conclusion for them. Regarding admissibility, I do not dispute that in the right context.
Do you mean the pool? Yes, that's my pool feed on the corner here. That's what you're asking? So I use Long Crime, and then I use the Zoom feed from court. I don't know. So yes and no, I guess.
Context, these text messages are admissible. If there is an investigator in a case that makes derogatory remarks about an accused, I can't say that doesn't go to bias, nor do I reject the idea that it shows an unfairness or a motivation. But really, you need to put that in context, and I think Attorney Yannetti highlighted that. He says that this is not hearsay, it's how he thought, or whether it affected a particular part of the investigation. It may have, it may not have. Even if he denies that it affected his investigation, it's still an appropriate question to ask just because that type of negative commentary, inappropriate commentary was made. But to explore the state of mind and put it in context, you need to ask the person that you're accusing of having the bias. Because perhaps it did affect the bias. Perhaps the person was very biased and made decisions based on that animus. Or perhaps the person made negative comments but had nothing whatsoever to do with the investigation. It is surmised to say because these comments were made, a witness was not investigated, or there was some other amorphous, undefined ill that happened. That's the whole reason why the witness who made the comments should be confronted with the comments they made so the jury can fairly assess, is this relevant, is it material, and what is the value of it? I am not opposed to the admission of bias against a witness, especially a police officer, but it should be against that witness because they need to have the opportunity to admit, deny, define, accept, and explain. By putting these messages in with sidestepping, calling Mr. Proctor, they are trying to gain the advantage of putting information in front of the jury that has no context, suggesting it has a value that has not been defined, and then, as Mr. Yannetti just did, making an argument that because the comment was merely made, that therefore there was a consequence, and specify a consequence where there's no factual basis to conclude. Because he made a derogatory...
Well, this act out, I do agree with one thing. So the other side of your argument is that Hank Brennan shows incredible confidence with his case. Says, sure, Proctor, bring Proctor in, confront him. I have confidence that once they see Proctor on the stand defending his statements and showing where they came from, that they're going to show that it didn't show that he wanted to frame Karen Reed or protect a police officer. I have confidence that a jury, after seeing all the evidence in this case, will say that that Karen Reed led the police to herself. All the evidence led right to Karen Reed. They didn't need any bias to do it. They didn't need to ignore anything else. And all the roads that the defense and the propaganda campaign says that the Commonwealth should have gone down would have just led them right back to Karen Reed. When they do go down these roads, like when they do try to look at some of the Free Karen Reed talking points, say about Chloe the dog, no dog DNA found on John O'Keefe. And then the Free Karen Readers changed the goalpost. Well, there was pig DNA. It wasn't that he may have eaten bacon or ham or something like that. No, it had to be dog treats, pig ears that Chloe ate. That's what was on there. Somehow she removed her own DNA and only the pig DNA was there. Or maybe wild boars came. Massachusetts, an area that they never are. And just sort of sniffed around him in the snow. I mean, they will make up crazy stories. So they can't let it go. They can't let it go. It's so salacious. They can't let it go. Can't be wrong.
Comment, he didn't investigate or speak to a plow driver for a year and a half. That defeats the purpose of defining the value for which this is being admitted. I do have some issue that it's really not under the context of Bowden, because this doesn't have to do with the adequacy of the police investigation. It has to do with bias. And that purely is the state of mind of the person who made the comment. I would not get in the way of confronting the witness about their bias if they were called to the stand. But to put it in this way invites speculation, it invites manipulation, and it invites a party on either side to portray this in a way that is not factually viable It will be distracting, confusing for the jury, and it could be unfair for either side because it will lead to arguments about what it means without a factual basis. And so my position is, I don't necessarily disagree that it's relevant, but it should come through Michael Proctor. And if the defense wants the value, they should call Michael Proctor.
Okay. Mr. Yannetti, do you want to respond?
I know we're 3 hours late, Your Honor. I won't belabor the points. I would state the following very as succinctly as I can, which is, yes, it goes to bias, but it also goes to the adequacy of the evaluation. The two concepts are intertwined. If you're biased or exhibit bias, the defense should be able to argue that the investigation was not adequate. I would note Mr. Brennan is not sitting at defense counsel table in this case. We appreciate the offer to help us with strategy about which witness we should call, but that's solely the province of the defense to determine which witness we want to use.
He wasn't giving that. He wasn't giving them points on strategy. He was saying legally, having to do with mass law, you have no standing to bring it in this way. Bring in Proctor. It wasn't trying to help your team out, Yannetti. It was cute the way you tried to deflect so you didn't have to argue your points about why it is a law again or get specific about any of that case law. You just say, oh, it deals with this. It doesn't say anything there. You have to actually talk about the cases that were brought up by the Commonwealth very specifically. I mean, you gave good outlines about what they're about. Not even a good outline. Bare bones outlines. It's a murder case. It had to do with these nicknames in this instance. But what a clever way to not actually have to really argue. And this is a real innocence fraud tactic. Just disparage the person. Yeah, Hank Brennan is so anxious to be a defense attorney and act as a defense attorney. He's giving us tips now. We rather, he can't play both roles, Your Honor. He's just going back to what he does best, which is being a defense attorney. We appreciate his advice, but we're going to do it this way. And we think you'll agree with us. Totally disingenuous. I mean, Hank Brennan was not, helping out the defense team. Saying, look, they want this in, if they want this evidence in, bring it in through Proctor. And Yannetti wants to say everything but we're never going to bring Proctor on the stand. But he does explain a little bit. He's going to explain why in 1 minute. He's going to say, look, spoiler alert, look, Proctor will come in and make the Commonwealth's case all over for them again. We don't want that. We don't want a closing argument by Michael Proctor. Thank you very much. We don't want him to reiterate and point to all the evidence that shows our client's guilt. We just want the unflattering parts, how he got fired with the mean texts. Maybe it'll shock at least one or two of the female jurors and turn them off and make them question all the evidence. Because we can't put together even a fantasy story about planning evidence because the facts don't line up. The car was already on, meaning Karen Reed's car was already on the way to the Sally Port when the CERT team was arriving. There was no time to plant the evidence. And who would really want to risk their career to plant evidence to frame the adjunct finance professor? He didn't have anything against Karen Reed, particularly, other than that all the evidence was showing them that she killed a fellow officer in one of the most cruel and callous ways. So of course they're going to be angry about her. Have anger towards her. But it's, they're making it in reverse. They didn't have anger towards her and then make the puzzle pieces fit. All the puzzle pieces, excuse the Rashbaum analogy, all the puzzle pieces or all the evidence was leading towards Karen Reed, and that made them not like her. Strangely, it seems to be going out of style, but there was once a time when it was pretty normal to have a distaste for killers. I know it's hard to believe with our media treating Karen Reed like she is the Queen of America, but there was a time once when being a cop killer, being a killer of anyone was a bad thing. Not so much anymore. Now it'll get you support a killer, now it'll get you big money, big views. But there was a time when people would question your character. You were supporting a killer.
Used to authenticate and admit text messages. That's our choice. And we should not be deprived of that choice because Mr. Brennan thinks there's a better witness that should have introduced the text messages. There is no rule. There's no best witness rule in this case. I believe my co-counsel has already made that argument in another circumstance. His arguments, Mr. Brennan's arguments, go to the weight, not the admissibility. He is fully entitled to cross-examine this witness about all of the points that he raises. And in conclusion, Your Honor, he complains that we have not called Michael Proctor. I think that's the whole impetus for this objection, so that we will call a witness that they do not have confidence in to call themselves. It's unheard of in a murder case that you don't call the lead investigator, but that's what's happened in this case. We should not be...
I think it's pretty standard to not call a police officer who's been fired if you don't need to.
Forced to call Michael Proctor so that Mr. Brennan...
They're calling it forced to call Michael Proctor. Forced. Yeah, you're forced when you want to bring in the evidence, you're forced to. It's not Hank Brennan who's forcing you to.
Can then cross-examine him and lead him through basically his entire closing argument.
See, there you go. That's it. Once they cross-examine him, he's going to make every point in their closing argument. So they're going to get another closing argument. He's going to bring up all the elements of her guilt. We don't want that. We just want the mean tweets. So Alan Jackson can feign and clutch pearls, feign horror in offense, feign offense and clutch pearls, and make one of his famous, statements that will get objected to and stricken from the record, but the jury will hear it. How dare you? How dare you, Michael Proctor? Darn you, Michael Proctor. Darn you to heck. Say, remember that silly? How dare you? You should be ashamed. All that silly acting he did, the same silly kind of acting he did. When he was giving his remarks to Peggy O'Keefe, his so sorries. Sorry for your loss, Mrs. O'Keefe, but I'm working hard legally and through really shady means to get your son's killer off. So, through witness harassment campaigns, propaganda campaigns, things that are way beyond the bounds of the rules of my profession and the law of the land, leaking evidence through unrelated court filings, working with the press to try this case outside of court. But I'm really sorry for your loss, Mrs. O'Keefe. What a disgusting display that was.
He is entitled to call Mr. Proctor in rebuttal. He has every right to call Mr. Proctor again. I would rest on that. Thank you.
Okay, and just the very last thing, there's Commonwealth's motion for reciprocal discovery. Is there any objection to that?
Yes, it's not in compliance with Rule 14.
Okay.
We don't have any written communications with Ms. Dever, and they've asked for all oral communications to be reduced to writing, to be turned over. That's not in keeping with Rule.
All right, so you're saying two different things. So you don't, this information doesn't exist because she has not had communications with you, right?
Written communications do not exist. I'm not saying two different things. Written communications do not exist. They also ask secondarily for all oral communications to be reduced to writing. We have no obligation to do that. We have no intention.
All right, so I'll get a decision out on that before 4:30, and I'm going to do a little more research on the text messages.
Wait, so that's something I didn't hear the first time around. What witness was that? So he's withheld discovery and communications with another witness? Did you guys hear that? Who's he talking about there? Alan Jackson. And he's not communicated with another witness that they plan to put up? I mean, tell us another tall tale, Alan Jackson. What is this?
Okay, and just the very last thing, there's Commonwealth's motion for reciprocal discovery. Is there any objection to that?
Yes, it's not in compliance with Rule 14.
Okay.
We don't have any written communications with Ms. Dever, and they've asked for all oral communications to be reduced to writing, to be turned over. That's not in keeping with Rule.
All right, so you're saying two.
Okay, so they're not going to hand over any of it. Was that the witness that they called today who was in court today? Is that someone else? I have to find that motion from the Commonwealth. I'll get back to you on that hopefully by tomorrow. Let me see if any of you know more about it than I do. Doesn't look like it. Looks like everyone. Who is the witness, though? Kelly Dever. She's a prior Canton cop, now in Boston. So apparently, would we think that she's on the Kelly Dever? She's a prior Canton cop, now in Boston, and she's ruled. So, but again, they're going to say they deleted them. And what are they going to say? They're going to say they deleted these messages. They never give over any of their communications with their witnesses. How are they going to, I mean, maybe they'll give over a few like they did with ARCA, but that'll be interesting. Again, it's their favorite thing. Ambush, 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 the Commonwealth. Hey, Manny. RG family. So what are the pros and cons of Proctor? What's going on with Tex and Jackson? So I'm just figuring this out now. So Kelly Dever, a former Canton cop, rumor has it, hostile witness. Probably, she was probably on that text message group, I would think. Oh, she's disgruntled with the Canton police. Oh, okay. Okay. You're welcome. Wow. That'll be curious to see what they come up with. She worked for Proctor. Oh, the Sally Port. She's going to say, prior to January, we put the videos the other way. Oh, some nonsense. Thank you. Okay, thank you. I'm behind all you guys with that. So should I keep it short today, or should I go on to the other stuff? Maybe we'll start the other witness and I can continue it tomorrow. So I'm going backwards. I just found this really fascinating. So she ruled against the defense, and they're going to have to bring in Proctor if they want to bring in Proctor and hand over their messages. Okay, so the other thing that is interesting that happened today, going back, is Matthew DiSorga He's an analyst. Thanks, Allie. The super sticker. Appreciate it. Whoop. And he just got murdered on cross-examination. I mean, really killed by Hank Brennan. Let's take a look at this brilliant cross by Hank Brennan. So he didn't write his own report, didn't do any reconstruction of his own, but he had a lot to say about. And he's saying that maybe there's a 3-second delay between devices, when we know that there was like a up to 29-second phone drift. So I think his point was, correct me if I'm wrong, is that they may be off in the phone drift time. I think that was his point. I'm not sure.
In here, so if you just speak directly into the microphone, that would be great.
Not a problem, Your Honor.
Thank you.
May I proceed?
Please.
Good morning, sir. Good morning, sir. Sir, are you trying to offer an opinion suggesting that Miss Reed's Lexus never hit John O'Keefe on January 29, 2022?
Objection.
Is that, I'll allow it. Is that what you're doing?
Is that your opinion?
No, sir.
Are you offering an opinion that Miss Reed's Lexus never got in a collision before?
The way I stated it was none of the prior events were triggered by a collision.
What I'm asking you, are you offering an opinion that Miss Reed's Lexus never got into a collision before January 29, 2022, or on that day?
No.
So when you were talking about collisions to the jury, you weren't making any suggestion that that Lexus was not in a collision, are you?
I think you threw a double negative in there. Can you just clarify what you meant? Yeah.
You are not suggesting to this jury that Miss Reed's Lexus did not ever get in a collision before?
No.
Okay. You're just saying that there's no data on the text string to suggest a collision.
Specifically, none of the events were triggered by a collision.
Right. Text stream data can be triggered by a number of different things other than a collision. Isn't that true?
Correct.
And in fact, when you talk about text stream data, you know that text stream data does not record a collision. You know that.
A collision is not one of the triggers. That's correct.
Right. So when you were saying it wasn't triggered.
Right. So this is what I thought was curious, is they had him in there saying, well, it couldn't have been a collision because it wasn't triggered by there was no trigger showing collision, but there's never, a collision will never trigger an event, one of these data events that we look at in the black box of these kind of cars. So it was kind of tricky presentation, meant to deceive presentation, I thought.
Triggered by a collision, it's never going to be triggered by a collision ever on text stream data.
Not the collision in and of itself, correct?
Right. Mm-hmm. Right. So there's other things that will trigger text stream data.
Correct.
Like sudden acceleration.
The only acceleration trigger that I'm aware of on text stream is if there's a large acceleration during what Lexus calls a PCS, or a pre-collision safety event. But a large acceleration on its own, I do not believe is one of the triggers.
Are you sure you know a lot about text stream data?
Yes.
Sustained.
Do you know a lot about text stream data?
Yes.
And you're saying that.
I love that. Are you sure he knows that's going to be objected to? He just wants to make sure that the jury's paying attention. Like, hey, jury, what a way to, that was a little bit of a dirty trick by Hank Brennan. Hey, jury, you think this guy knows what he's talking about? Because he just presented it to you like it's a big thing that there wasn't any signs of collision. It's like, you're not saying that there wasn't a collision, right? That's how he starts it out. Let's talk, real talk here, right? You're not saying that Karen Reed didn't hit John O'Keefe with her car. Hey, Allison from My Father's Alibi channel. Nice to see you. Allison Galvani. Fighting for justice for her mother, Nancy Galvani. Check out her channel. Thank you very much. It's very generous of you. Nice to see you.
And if a car accelerates over 30%, in and of itself wouldn't initiate a trigger?
I'm not sure I understand.
You just said pre-collision is the only time sudden acceleration, from your perspective, would cause a triggering event. Now, I'm asking you,
I'm allowing this.
if someone accelerated Miss Reed's Lexus at over 30% acceleration, would that cause a triggering event?
I am not sure what you mean by 30% acceleration.
Accelerator, 30%.
Accelerator pedal.
Yes.
Oh, yeah, there's a lot of triggers there's a number of ways that these VCH events can be triggered based on the accelerator pedal angle. I think, yeah.
And what is the percentage from your experience that would create a triggering event?
There's various. Toyota, Lexus calls it high, medium to high is what they put it.
Do you have a number? Do you know the actual data on what percent of pressing the accelerator on the same Lexus as Miss Reed's would
See, we learned this, that it was 30% from the testimony from the Commonwealth.
create a triggering event? Do you know?
Off the top of my head, I don't know the exact percentage down to this percentage point, no.
There is something different than the text stream data. That's the EDR data, correct?
Yes.
You would not expect, it would be abnormal for the EDR to register data based on a side swipe between a 6,000-pound Lexus and a 216-pound person, wouldn't it?
Objection.
I'll allow it.
That would be abnormal to register that data into the EDR, wouldn't it?
I don't know if I would use the word abnormal, but I would state it that there's a minimum threshold to record in the EDR, and a pedestrian impact generally wouldn't meet that.
I'm sorry.
A pedestrian impact generally wouldn't meet that, but I don't want to make a blanket statement as if it's always the case.
You're saying it would meet that?
Would not.
Would not. Okay. And a side swipe or a clip has less force and impact than a head-on collision, depending on the speed, correct?
Generally, yes.
When you are discussing the triggering event, that is the moment that something registers to the car to capture data in the text stream, correct?
Correct.
So if I was to suggest 30% of depressing the accelerator pedal would cause a triggering event, would the triggering event be when it reaches 30%?
Yes.
The event data captures potentially part of an event, doesn't it?
I think we're into semantics a little bit, and I think it depends on what you mean by event.
Exactly.
Because previously we'd been talking about an event as the data, but event can mean a lot of other things.
If an event's only 3 seconds long and 10 seconds of data is captured, then the data will capture more than the event, correct?
Correct.
If the event is longer, 15 seconds, 20, 25 seconds, and the data is only captured for 10, the text stream data only captures part of the event.
Correct.
Fair to say?
And then there's the main event, Frank Sinatra's great comeback on concert, Madison Square Garden. So I'm not sure which event you're talking about. That's what I thought he was going to say.
Very fair.
So when you're looking at the data, it doesn't tell you about the entire event, correct?
The data only tells us about the window of time the data captures. There's no way to know beyond that from the data.
All of your equations and pluses and minuses and graphs you're talking about deal with the 10-second text stream data that was captured, correct?
They deal with event 1162.2, right, and the 10 seconds it's comprised of. Actually, they really just deal with the end of the event. That's what everything in the Aperture reports reference.
Fair enough. But it doesn't deal with anything that could potentially happen after those 10 seconds, does it?
No.
or anything before.
No, it does not.
The triggering event is spot in the middle, captures 5 seconds before, 5 seconds after.
Approximately 5 seconds. It's not exact.
And you would have to look elsewhere for evidence to know what might have happened before. Yes?
Correct.
And you'd have to look elsewhere for evidence to see or determine what happened after.
Yes.
Do you know at the end of this triggering event, that 10-second window of data, do you know what happened with the defendant's Lexus after that 10-second of data?
No,
You have no idea, right?
I don't.
Okay. I want to just ask you some questions about your background and then leading into this case, if I could.
I mean, a really good way, what Hank Brennan has just established here is I'm not here to present an alternate theory. I'm here to just poke holes in the Commonwealth's case in a way that doesn't even come to a different conclusion than the Commonwealth, because I don't have a story to tell you, an alternate story to tell you that uses all the evidence.
You have a bachelor's degree and a master's degree.
That's correct.
You've worked for your company for some time.
Coming up on 13 years next month, correct.
You've advanced through the company.
Yes.
You presently are the director of engineering.
Yes.
Are you ACTAR certified?
No.
What is ACTAR?
ACTAR is a body that basically offers a certification in accident reconstruction.
Do you offer services as an accident reconstructionist?
Sometimes.
And you have been hired and come into court and offer opinions as an accident reconstructionist?
In the singular time I've testified in court, it was not specifically for accident reconstruction, it was data analysis.
Okay. You continue your education and you go to a number of different trainings and seminars as well as teach, correct?
Regularly.
Then when you regularly go to continuing education, you have quite a bit of continuing education that you've been through, haven't you?
Sorry?
You've been through quite a bit of continuing education.
Yes.
You focus, as part of your specialty, on EDRs, don't you?
That's correct.
Event data recorders?
Correct.
In fact, when you promote your services, that's one of your real specialty, isn't it?
Correct.
And it's something that not only are you schooled on and you go through continuing education, you're well published, aren't you?
That's correct.
And in your publications, you speak primarily about EDR type information.
Yes.
And that's something you are well skilled in, isn't it?
Yes.
Now, forensics or data forensics is a wide field, isn't it?
It is.
And you can do some things or many things in it, but oftentimes people specialize in parts of data forensics, don't they?
Generally, yes.
Well, speaking of you, you specialize in EDRs, true?
Yes.
There is a difference in different subspecialties, isn't there?
In general?
Oh, yes.
Yes.
Okay.
So just to give you an idea of who Matthew DiSorga is, this is his company, Delta, and it goes to clients. So actually, let me go back. So they're Charlotte, North Carolina, Atlanta, Georgia, Nashville, Tennessee, Fayetteville, Arkansas, Denver, Colorado. Expertise where and when and where you need it. Here he is in Charlotte, North Carolina. Matthew DiSorga, Director of Engineering, EDR Services. And they have their corporate team, part of their corporate team. I mean, they look like just hired guns, kind of digital media, accident reconstruction, biomechanics, your go-to firm for resolving high-stakes vehicle accidents. Yeah, you could. But when you actually go to their clients, usually this is where you get like a whole client list. And you don't get any of their client lists. This guy's only testified one other time in trial. So I would have a feeling that I don't know what to think about these. You know, what do these guys do if they're not testifying in court? He's like a main guy in their North Carolina. Odd, right? I don't even know what to say about it. It's odd.
Now, are cell phones, is that a subspecialty in digital forensics?
Yes.
Is that something you're a specialist in?
No.
iPhones, are you a specialist in iPhones?
No.
Have you ever taken any specific training on mobile forensics?
No.
Have you ever written any papers on mobile forensics?
No.
Hey, have you ever promoted yourself of having any type of subspecialty as an expert in mobile forensics?
Never.
In any of your continuing education, and you have a vast amount, have you ever taken any classes or seminars in mobile forensics?
No.
Have you ever taken any class or study about variances between infotainment systems and mobile forensics?
Classes? No.
Have you ever attended any seminars on variances relative to mobile forensics?
No.
Have you ever testified about variances in mobile forensics before you testified in this court today?
No.
Have you ever published anything to do with variances in mobile forensics?
No.
In this case, you had an opportunity to review a number of...
I mean, what are they doing all day is my point. This is a full-time job. This guy is the main guy in their... I mean, when you go to about like our team, he's the main guy in the North Carolina office. If they're doing this all day long, they should be testifying in tons of civil cases, criminal cases. What is this? Is this like a tax judge? What is this? Delta team. Rapid race, industry focus 1, annual investigation, 1,600. For whom? They don't say. Digital media. Are they just making PowerPoint presentations? What do they mean, investigations? I don't get it. Look, let me show you. Rapid response time, industry focus 1. What does that mean? Annual investigations, 1,600. Solely focusing on accident reconstruction. Delta 5 stays on the cutting edge of research, technology, and analysis. This specialized expertise is in demand for thousands of cases annually, many requiring our rapid response capabilities. But he's only testified in one trial. And he's been there for years. I find that odd. No? Anyone else find that odd?
Reports from Dr. Judd Welcher, yes?
Yes.
And Mr. Shannon Burgess?
Correct.
In reviewing those reports, you've offered your opinions and analysis. Did you ever engage in actually any efforts or study in this case to obtain data?
Could you maybe clarify what specifically you're asking?
Yes. Did you ever yourself, not watch someone else do it, did you ever download or obtain data in this case?
No.
Did you ever test Miss Reed's car?
No.
Did you ever get an exemplar vehicle to run any tests?
I did not.
Did you ever do any actual testing in this case?
No.
And so your role is to look at other people's work and offer opinions and criticisms, basically.
And provide some clarity to the work, but generally, yes.
Clarity for who? Who asked you to provide clarity?
My clients in this case.
You what?
Mr. Jackson,
Right, okay.
my client.
Did you ever speak to me?
No.
As an expert, when you analyze data, whether you actively got it yourself or not, do you ever give an opinion in paper called a report? You ever write a report?
Yes.
And you've seen reports in this case that you've looked at, correct?
Correct.
A number of reports by Mr. Burgess,
Correct.
report by Dr. Welcher,
Also correct.
reports that you're critiquing, right?
Correct.
Did you see Ian Whiffin's reports?
I did not.
How about Jessica Hyde? Did you see her reports?
I did not.
You were asked to consider information from Mr. Whiffin's report.
No.
Well, you were asked to assume that the last user interaction on John O'Keefe's cell phone was 12/32/09.
That was stated in Dr. Welcher's report, so I started my analysis at that level.
So none of the information did you actually personally go and vet or analyze or make any determinations about. You're just critiquing written reports.
Correct.
Well, as an expert coming into court and testifying and having opinions, you put together a PowerPoint, didn't you?
Yes.
Why didn't you ever put together a report to share the basis of your opinions and the process you went through to arrive at your opinions before you came into court?
Because they wanted to ambush the Commonwealth. That's why they would tell an expert not to write a report. The common tactic by the defense teams is to have their experts not write reports so they don't have to share their opinion with the Commonwealth. And this has been the defense tactic. I don't know why I'm the only one talking about this. Over and over and over again, to hide discovery from the Commonwealth so they can ambush. That's a main strategy of Karen Reed's defense team. Hide communications, hide discovery, hide report. If there's a report, make it as vague. Hide communications, hide what you're going to do with this witness. I mean, we've had to have so many voir dires in this case. Instead, they handed over this PowerPoint.
Primarily, I wasn't asked to, so I didn't do it. I wouldn't commission work without being asked to do it. And number two, the extent of my work beyond building the PowerPoint was just basic addition, just adding numbers together that already existed in the Aperture reports. So there wasn't a tremendous amount of complexity to what I engaged in.
What about your work product and your calculations? Did you do all this in your head, or did you type it out and go through a computer program? How did you do it?
I used a calculator for most of it, and the tables in my PowerPoint were generated in Excel, which has some calculation capabilities.
Were you ever asked not to write a report?
No.
You had provided an initial PowerPoint,
Yes.
and then you received information from Mr. Burgess,
Yes.
and then you added new slides to your PowerPoint.
That's correct.
Mr. Burgess's report was May 8th.
Yes.
You provided your PowerPoint on May 25th.
Correct.
Did it take you that long for the calculations between when you got the report and May 25th to put together the new presentation?
No, it didn't.
Why did you wait until May 25th to provide the new information?
Right. So here we can go back, but let's just go back in time and remind ourselves how angry Alessi got when he thought that they were, what? Hold on one second. And they thought that the Commonwealth had amended their presentation.
The rest of the jury.
Oh, what? Let me just, sorry.
Nature and significance of the information is the...
I'll hear you, Mr. Lessie.
Thank you, Your Honor. The topic I would like to raise with Your Honor is the timing and nature and significance of the information that the defense has received from the firm Aperture. And Your Honor may recall there are two individuals on the witness list that we understand are to testify in this matter. First is Dr. Judson Welcher, and the second is Shannon Burgess.
And are they testifying in reverse order, though, than what you said?
My understanding is, Your Honor, yes.
Okay.
My understanding, Mr. Brennan has the best information, is that it's proposed that Mr. Burgess testifies first and Dr. Welcher testifies thereafter.
Okay.
So the Commonwealth has established in reports right up until not established, they had stated in the reports of Aperture, particularly the slide presentation of Dr. Welcher, a trigger called 1162-2 that they had associated in the report of Dr. Welcher with a specific time. And that specific time that they have associated with that trigger is 12/31/38 to 12/31/43. And we have been assuming that information, and this is from best memory, but I believe it's slide 137 or so, where the statement is in the slide. And so we have proceeded with our defense. We have proceeded with the work that has been assigned to ARCA based upon that time period. On May 8th, not too long ago, Your Honor, we received an amended report of Shannon Burgess that pushes that time period. I'm just going to get it. So, although it was dated May 8th, we received it actually on May 11th. And in that report, Mr. Burgess states that he is making an amendment, and he is now stating that that infotainment trigger of 1162-2 is further back in time, and it is past 12/31/43.
Do you have the time?
I'm going to get the exact time, Your Honor. It is 12/32/16. And Your Honor may recall that the seconds, literally seconds, matter in the analysis of many factors. I won't go into them other than to say I went through and developed testimony with regard to the cross-examination of Mr. Whiffen. He had a timeline. He talked about much human volitional conduct. Suffice it to say that that information is literally by seconds determinative in some ways of various analyses. So we basically commissioned, if you will, ARCA to be looking at matters based upon the infotainment trigger 1162-2 of 12/31/38 to 12/31/43. As of May 11th, we received information that has changed that. Now, Your Honor, that is a Rule 14 violation, among other issues, but I wanted to start there. It's a Rule 14 violation. It's obviously, as I stated, an amendment of a report of a significant matter. And also, with regard to the defense's ability to provide a defense, we have to be able to evaluate that information in terms of our entire defense. And it's just not limited to ARCA, it's our entire defense. The other data point I want to get to, so the effect it's had, we still haven't even been able to evaluate entirely that. And I believe, Your Honor, based upon the information that I have, that this may have been a calculated matter by the Commonwealth, but even assuming it's not calculated, the effect is pronounced. So what I want to do, Your Honor, is to look at what the reason Mr. Burgess has given, which leads me to be very concerned about a calculation and a strategy calculation here. Mr. Burgess states in his own words that the reason why he is changed, that time is being changed, is to, quote, align the trigger with Mr. Whiffin's analysis. And Mr. Whiffin's analysis is based upon the extraction data from Mr. O'Keefe's phone. And I believe it's undisputed that the extraction from Mr. O'Keefe's phone occurred years ago. And the data from that has been extant, it's been available years ago. So to me, Your Honor, that basis can't be a proper basis at particularly this stage where we are approaching the end of the trial, just literally days before the testimony of Aperture, and we are in a very, very almost impossible, challenging situation. So, Your Honor, there are obviously, Your Honor knows the situation here. Our first request is that the May 8th report that we received on May 11th be not allowed, that it be not considered at all. As Your Honor knows, I don't like to use hyperbolic words, but the word has been used for us, against us, ambush, ambush, ambush. If there's ever an example of an ambush, this is it. And so, Your Honor, our request is that Your Honor find a Rule 14 violation, that Your Honor have the remedy be that the violation remedy be that this is.
So does everybody get what's going on here? He's saying that this is really the well, sorry, hold on. This is really the violation. They're really ambushing us. It's the defense team. Thank you, Vicky, Mom 06. Vicky's Mom 06 for the super sticker. I appreciate it. It's really them who's ambushing, not us all the way around. Not last trial where we had to have voir dire after voir dire after voir dire. It's the Commonwealth ambushing us. So what did they do? I just wanted to go back in time and remind everybody that they got their own report, not report, I have to keep calling it a report. It's a PowerPoint presentation. And they handed it on the 25th. And they presented it in court on the 30th. So 5 days for the Commonwealth to look at it and respond to it. Thank you. Tricks are for kids. So just a little, I'm going to try to keep this shorter. We can go over some of this more tomorrow, but it will give you an idea of some of the lack of candor. That's what Judge Cannoni calls it, lack of candor, i.e. straight up lying, dirty tricks. I'll call it what it is in this case. And so there are so many small cases that never go to trial, but I mean, not even to testify in the deposition, nothing. For a civil case, nothing. So one other trial, the first trial he's ever, one other trial he's done, or is this his first or second trial? It's crazy.
That's when I was asked to do it.
What do you mean by that? I just want to see what the date is today. Today's the 30th. When you finished your PowerPoint on May 25th, did you send it to the defense on May 25th?
Yes, I did.
So they had a copy of your PowerPoint on May 25th? Don't be shy.
No, I'm pretty sure it was the 25th.
So it's sustained.
Don't be shy. And what he's pointing out there to the jury is, why is he thinking about his answers so much? Why isn't he, if he knows the stuff cold, why isn't he spitting it out? Why is he hedging so much? That's a way to get a message across to a jury. It doesn't matter that don't be shy has been struck. He's still communicating with the jury. He's having a little dialogue with the jury, even as his comments are being struck. There's another sneaky trick by Hank Brennan.
Yeah, if it wasn't the 25th, it would have been maybe the day after, but it's dated the 25th. I'm almost positive I provided it on the 25th.
There's no reason for you to hold on to it for a couple of days.
No, I think it was the 25th.
Do you know what was provided to the Commonwealth, that report?
No, I don't.
In the 25th, the report that you provided to the defense on the 25th, it had new information, didn't it?
It had the information from Mr. Burgess's supplemental report. That was the additions.
Why did you wait until the 25th to put it together?
That's when I was asked to do it.
Who asked
My clients, Mr. Jackson.
you? He said, please add this on the 25th.
We had a phone call on the 25th and discussed Mr. Burgess's supplemental report. During that phone call, he asked me to update the presentation, and I did so, and then provided it.
How did the date of the 25th come about? Why the 25th was the date you provided?
That's when he requested it. I think it was a Sunday, actually.
Okay. When you first got involved in this case, it was last fall?
Correct.
And at that time, you received some information that Mr. Burgess wanted to look at the text stream data or the different modules on what you later learned was the defendant's Lexus, correct?
Correct.
There was a proposal from Mr. Burgess. Mr. Burgess wanted to go back to the car and look at the modules to try to download more information from them, correct?
Correct.
And you then got involved to look at what his request was, the procedure that you wanted to follow.
Yes.
When you did that, were you given any materials about what had happened before you and Mr. Burgess both got involved?
I don't recall specifically, and I don't think so. I think I was just provided the notice of testing that was to be done.
Well, you ended up drafting an affidavit.
I did.
And in drafting an affidavit, you pointed out some oversights of Mr. Burgess, didn't you?
I did.
Determining the oversights required some study of actually the data and the information that was available, wouldn't it?
It would.
So, can we presume that before you wrote the affidavit pointing out the oversights, you had looked at other materials?
If I recall correctly, the notice of additional testing from Mr. Burgess contained attached to it a whole report by him documenting why he thought there was an inadequate initial acquisition, why he thought the sizes were wrong. So I don't remember referencing anything beyond all the information that was contained in that. And whether that was combined by somebody else or not, I don't know. That's how it was provided.
Did you end up looking at the report of Ms. Gaffney and what had happened in the past with the download and search of Ms.
I just want to thank the over 700 people who are watching on X or Facebook. If you're watching on YouTube, please hit the thumbs up. Share this episode. Support the channel. Links are always in the description. I want to thank Emma Evans for sending a donation via Venmo. Great way to support the channel. Also, buy me a coffee and also Patreon, where you can get access to a whole heap of content not available anywhere else.
If I'm remembering right again, I think Ms. Gaffney's report was also attached to that same singular file.
You learned that the defense expert, Ms. Gaffney, had downloaded data from chips, correct?
Correct.
And Mr. Burgess was asserting that there was information missing and believed that there was missing information from the chips.
Correct.
In that form, it's sustained. It's stricken.
My apologies. The conclusion Mr. Burgess had is that he believed there was missing information from the chips.
He did. He miscalculated the size of the chips.
Did you do any study to see if there was actually information missing from the original download?
No, I looked at the data sheets for the chips and then immediately realized what the error was. The data sheets specify a size in megabits or gigabits, and Mr. Burgess had written his report in the context of megabytes and gigabytes.
And then you asserted, or you took the position in your affidavit, that there should be no further chip loss, no further study of those chips, other than to ensure the amount of memory was sufficient.
It's not how I recall specifically what I said.
Well, let me read it because I don't want to try to malign your words.
Please.
Mr. Burgess' proposed protocol labeled "Reattempt chip-off acquisition is unnecessary because the file size of the acquisition performed by Ms. Gaffney already matches the expected memory storage capacity of the components."
That sounds accurate.
If you want to see this, I don't want to read from the document. If you need to see it actually, just let me know.
That's fine. I trust your reading.
However, an acquisition may be conducted for the sole purposes of ensuring the contents of the memory chips have not been altered since the last testing by recording the checksum.
Yes.
Did it cross your mind at that point that there was important data in those modules that was not seen or recovered or obtained by Ms. Gaffney?
Right. This is so interesting. This is the first time the defense downloaded the car data. They got strangely, for Karen, in Karen Reed's favor, the defense expert downloaded the black box data and only got a small portion of it, missed crucial data. And now Hank Brennan's asking what he thought of that. Pat Brooks, thank you so much. She says, "Thank you, Roberta, for all you do. Love and appreciation to you. Awesome mods." I do have awesome mods and an awesome community. Thank you, Pat Brooks. Appreciate it. Whoops. Sorry, RIP your ears. Monica, thanks for the super sticker. All right, here we go.
No.
Did you want to know when Mr. Burgess was looking for more data, more information, what he thought was missing?
He stated, I think, in his report or affidavit, I'm not sure what it was, but he stated what he thought was missing was there was a physical size difference. So he thought there was not corrupt data, but just missing chunks of data.
Log on information, you've heard of that. Ignition on and ignition off information.
Yes.
And an infotainment system. That's important information when you're reconstructing an accident, isn't it?
It could be.
Well, you read information in this case. It's pretty important in this case, wouldn't you say?
Yes.
And so you would not want to engage in that process without this pretty important information, would you?
Which process?
Of an accident reconstruction?
Sorry, so can you restate it, the whole question? Yeah. Yeah.
You said you have some experience in accident reconstructions.
Yes.
Don't you want all the data available? More data, the better?
Generally, yes.
You wouldn't want to ignore.
Really? You're not like ARCA, who doesn't want more information? They wouldn't change their opinion if they had more information. A. Donald says, don't be shy, Roberta. In chat, a classic Boston expression said with much sarcasm. Yeah, Hank Brennan. Hank Brennan is really giving it to him. Melina, thanks so much for the super sticker. So this guy, unlike Arca, who just want the information from the defense team, don't want any more information and wouldn't change their opinion if they got more information from the Commonwealth. It's called being a hired gun, my friends. A hired gun.
More data on purpose, would you?
No.
I mean, as a data analyst, the more data, the more you get to look at.
Yes.
And so the power log on information that actually has date and time, that's critical in an accident reconstruction, isn't it?
In some accident reconstructions. In some, there's no debate about when a vehicle was on or off, but if there is, then yes.
Not just on and off. The power log on and off gives you the date and time that has been matched with the texturing data, correct?
Yes, it does.
You know texturing data itself doesn't have date and time.
It can, this vehicle didn't. It can, but this vehicle did not.
This had a running time instead. Like
That's
a stopwatch.
correct.
So this data that was not found during the initial process, that was critical data at the time.
I don't think prior to the process anyone knew that this particular Lexus infotainment system stored those key on and key off times.
Right, the only person that found this out was Shannon Burgers.
He found it in the process, but I don't think anybody knew in advance of this case. There was nothing out there about it. So to my knowledge, this is the first time that this specific data has ever been released into the wild.
But it was on the board there. If someone knew what to look for or got creative, they could maybe find it.
Yes, more so to your if got creative, because I don't think anyone would have been able to have the foreknowledge that there would have definitely been that.
Shannon Burgess did.
Sustain. I'll strike it.
And when Shannon Burgess went to obtain that data that everybody else overlooked or didn't know about, you went with him.
Yes.
So you had a process where he was going to now control the data and take the information that was left behind and remove it from the infotainment board, correct?
He actually never specified anything about the SD card in that initial notice. So it was a departure from his protocol, and it was a little surprising to me when I got there that the protocol was written with a specific focus on a number of other chips, and it became very apparent to me very quickly that the focus was not on those chips, and the focus was on this SD card that had previously been unmentioned. There was nothing in there about that prior to that.
Did it offend you, or were you impressed that he had found that?
I was a little confused because I went into it with an expectation. Generally, if we write a protocol, we adhere to the protocol. If we're going to deviate, we have a discussion about deviations. So I was just surprised. It's not customary to sort of shift out of nowhere. But other than that, I did not know what to think of it because I'd never heard of that.
Did you give any input? Did you have any knowledge about the SD card and how it worked?
No.
So when you watched Mr. Burgess remove the SD card, did you appreciate he'd have to engage in what you call reverse engineering?
He did not elaborate to me exactly what his whole process was at first. It sort of came out as time progressed through the first day in his office in Texas, and then I learned more as we moved to the second testing in Massachusetts.
Oh, let me reflect. Thank you so much. Roberta, I love the meat blob. Those are for, those are special emojis I made for the members, channel members. Made a meat blob emoji and a tight pants emoji. It's actually the second version. First version I thought was too hard to See, there's also a spinning fan emoji, a psychopath emoji, a Hank Brennan emoji, making the shh. Those are all the little perks you get being a channel member. Did you hear Jackson tell Matt from Court TV about his meatloaf? I didn't. Send me the link. I'm on X, Roberta Glass 23 at Gmail. Email it to me. I'd love to see it. Okay. I'm gonna wind this down soon. We still have a lot of ways to go, but this will give you an idea of how to absolutely destroy the credibility of a witness. This is a masterclass in.
He didn't explain it to me in one go.
Done by Hank Brennan. How to destroy a witness's credibility and make his presentation totally null and void.
Understand or appreciate the relevance of the SD card relative to the infotainment system and what it could do as far as the amount of information that could then be available?
He never spoke throughout the 3 days at all about what kind of data he expected from the card or would be on the card or could be. He made no mention of the data.
Not what he said to you, but given your expertise, did it ever dawn on you the significance or importance of this SD card that was sitting in plain sight? Objection.
Sustained, you can ask it to.
Did it ever dawn on you, as Mr. Burgess was recovering this information left behind, that there was something important or significant about it?
At the time, I thought it was a possibility. If you reference the initial work, a number of different memory components were identified in this infotainment. There isn't a singular memory chip. So if we're looking for data, it could be in any of them. So we found a new source of data storage, and there could be something there, there could be nothing there. It was unknown to me.
But it turned out.
It was unknown, but it turns out there was some data. It's shocking. All right, that's where I'm going to leave it for today, guys. We've been going for a long time. Do I think the defense is getting nervous? Tricks for kids. Thank you. Do I think I think Hank Brennan. I think Alan Jackson and Yannetti, and even Karen Reed. She says that, she said that they're playing hardball this time. And by hardball, she means, the Commonwealth has an advantage. They've gotten to edit their case down quite a bit. And they know how someone's going to testify now. Hank Brennan, Lally, amazingly, with a judge who completely just was so dismissive and rude to him in court and ruled against him almost every time, 9 times out of, for every 1 time she ruled for him, still got a hung jury with this amazing, all-powerful propaganda machine known as innocence fraud that the press jumped on and is still jumping on. I'm just amazed every time I see, because they're fraudsters. They love it. They hate the police. They want these killers to get away with it. They love an innocence fraud campaign. It means clicks and views for them. They treat Karen Reed, with kid gloves. Never a second question, never a hard question. I don't know why I'm shocked. I've seen it so many times before. I don't know why I'm shocked. Hold on. But it's just incredible. So, it'll show you what a good lawyer Adam Lally is. Now, I know he's not an entertaining lawyer. I know he's not a showman. But boy, is he a good lawyer. To even get a hung jury with everything pushing for an acquittal. If you watch, we'd have these devastating days in court. to Karen Reed, and then the press would run with some, minutia like Sallyport video footage being mirrored that meant nothing. It really ultimately meant nothing. So obvious, right? So, yeah, I think they know that it's not going to turn out. I think Yannetti and Jackson know that they have an uphill battle. They're counting on the fact, hoping that there's maybe some free Karen readers in the jury that can bring it home for them and get an acquittal on some of the more major charges. But it seems like they've all but given up on the drunk driving charge. I mean, Karen Reed admitted she had 9 drinks. I mean, what more do you want? And drove with that. Plus, her blood alcohol content. I don't know what more the jury wants on that charge. Watch that be the one charge she gets acquitted of. But as for the other charges, I don't know who's on the jury. I don't know how they're thinking. But to me, and, when I hear someone say, oh, last time I thought she should be acquitted, I think, oh, you didn't watch the trial. It's very obvious last time she should have been convicted. It was an overwhelming case last time. It was just a harder case to watch. And I think fewer people watched it from beginning to end. That's how I feel. And watched it without any kind of bias brought on by our media, who really became another wing of the Karen Reed's defense. So that's what I have. I'll be back tomorrow at 6. Thank you so much for watching the trial with me, supporting the channel. If you'd like to support the channel, these episodes are supported by you. Links are in the description of this episode. Buy me a coffee. Great way to support the channel. Venmo. Great way to support the channel. Also, Patreon member. Become a Patreon member. Another great way to support the channel. And you get a whole bunch of content, access to content you won't get anywhere else. Or become a channel member and get the meat blob emojis and early access sometimes to episodes and shorts. Who doesn't want to use the meat blob in a tight pants, a Leslie's tight pants emoji? All right, have a great night, everyone. Thanks so much for listening. I'll see you tomorrow at 6.
I hit my boyfriend with my car. It wasn't an accident, but with lying lawyers I'll go far. Lying lawyers and witness harassment. I'll avoid prison. It was snowing. I pushed the pedal down, hit him hard. Now the legal system I clown. Innocence fraud campaign to save my skin. Making money, truth is my second victim. Carry, I pushed the pedal down, hit him hard. Now the legal system I clown. Innocence fraud campaign to save my skin. Making money, truth is my second victim.